Ladies and gentlemen, hello. Members of this committee, we're fixing to start. I got something to do. Y'all ready? Okay, this is the Governmental Affairs Committee, and we welcome you here today, and to let you know we have two bills. Is that what it is? Yes. Two bills on the agenda. And first one, Miss Oliver, if you would like to do from your chair, if you would. What number are you?
25. Thank you, Mr. Chairman. House Bill 20 passed out of your subcommittee last week without opposition, without anybody opposing it. The Administrative Procedures Act is enacted for all our state agencies for the purpose of granting vendors, citizens, legislators, and everybody in the public information and transparency over rules and regulations implemented by agencies. I think that it's a good law. It's been in effect 50, 80 years, and it procedurally simply requires an agency to do a notice that they are about to adopt a rule, and they have to give 30 days notice. If there's opposition, if there's a hearing process later, they're required to have some kind of hearing in a timely manner. I am asking the committee to favorably pass House Bill 20, which removes an exemption that the DHR got, I believe, inserted into the law about 40 years ago, that exempted them from certain ways they have to do rulemaking. Those of us that know our constituents have a lot of interest as vendors with DHR, and as legislators, we also are entitled to notification of rules. Rules frequently are passed by an agency to interpret a state statute. If we pass a statute that says X, they have the right to interpret it, and we have the right to know whether or not that interpretation is accurate with our intent. So for the purpose of transparency, for the purpose of service to our constituents, our vendors, people that do business with the state, taxpayers, and legislators, I think that a more uniform application of the rulemaking process would be appropriate. We've had a Georgia Supreme Court case that's come up this summer out of DCH, Department of Health, Medicaid Health, about their rulemaking process and the way which they were in error in adopting a particular funding stream, fee stream for a vendor, and the Supreme Court said that they didn't do the rule making accurately. So I introduced this bill at the last of the 2008 session, and I pre-filed it, and of course we had no opposition in the subcommittee, and about an hour ago DHR emailed me some objections they had to it. If they're going to testify about those objections today, I'd be happy to respond. But I'm not going to make their case for them if they're not going to make it themselves. I'm happy to answer any questions, Mr. Chairman.
Any questions from the committee? Audience. Not really, but I'm going to let you say something if you'd like.
My name is Kari Hunt. I'm Assistant Commissioner for the Department of Human Resources. We have a few concerns about some unintended consequences of this legislation, so I'd like to share that with this committee. Briefly, we anticipate that it may have a negative impact on the Department's ability to comply with federal law. Frequently, our federal partners ask us to make policy or rule changes, what you might describe at the drop of a hat. And if we're not able to implement those rule changes immediately, we suspect that it may jeopardize some of our critical federal funding. Secondly, we believe that it may impede the Department's ability to make timely decisions on critical policy changes that affect the safety and well-being of vulnerable families and children. And finally, we expect that it will increase the Department's administrative expenses for public hearings, notifications, and mailings that are associated with compliance with the Administrative Procedures Act. I can give you briefly some examples of each one of those points. When we talk about funding, one example is in Medicaid. The bill would specifically violate the current terms of our contract with DCH, which requires our policy to be updated within 10 days of issuance. It may also delay complying with federal guidelines to an extent that it makes us liable for penalties. An example for child support services is that in October of 2000, the Deficit Reduction Act of 2005 became effective. If this bill had been enacted at that time, child support would not have been able to act as quickly as it had been able to. It may have lost the opportunity to intercept some of the economic stimulus checks that taxpayers received in 2008. As a result, the state and, more importantly, people who receive child support may have lost an additional $18 million in child support arrears that we were able to collect from the economic stimulus checks. Some examples of the impact on safety and well-being. In public health, on occasion, drug and vaccine shortages or problems discovered with a certain drug or vaccine require an immediate change in the formulary or dosing schedule to protect the health of our citizens. Lives could be potentially endangered or left unprotected if we're not able to immediately adapt our policies and procedures in these circumstances. An example in child protective services, intake policy needed to be changed to assure that reports of child abuse and neglect included thorough collection of information and prioritization of response for the most serious reports. This change was made within 2 weeks, as opposed to the 60-day minimum that would be required under this proposed legislation. So I have some additional examples, and I can share those with the committee. I can share this document with the committee. But we just urge legislators to consider the unintended consequences of the bill before its passage. And as always, the department is available to meet with legislators to address their concerns in a way that together we can jointly protect the safety and well-being of Georgia's families, as well as the funding that supports that work. Thank you.
What was your name again?
My name is Khari, Khari Hunt. I'm Assistant Commissioner at the Department of Human Resources.
Okay. Ms. Oliver.
Mr. Hunt, I think you may be a little bit of a disadvantage, and I don't want to be unfair to you, but sure. Did you write that report you just read?
I did. I managed the development of this report. That's
okay.
Right.
Would you explain to me why a child support policy is either a loan, grant, or benefit, as the statute is proposed to be enacted?
The benefit of child support, of providing child support.
I meant to say child abuse. Excuse me. A child abuse investigation policy. Tell me how that is a loan, grant, or benefit. Only
as it's associated with potential benefits related to bringing a child into custody. And in this case, with the intake example, if the intake isn't taken in properly, not only do we anticipate that there might be an impact on the safety of that child, but as we've seen in our 4E collection.
Isn't it true that you already are required to do rulemaking under policies in relation to child protection, and that this statute only relates to loans, grants, or benefits, and not in terms of protection action?
Correct. And I think what we would want to do is be very clear about what the definition of loan, grants, and benefits includes. And
do you know exactly what the procedure is that DHR complies with now in its rulemaking?
It's different for different divisions.
Okay. What is it for defects? For
defects, I can't quote to you the exact process that they go through for every policy. I do know that they do engage the public and stakeholders in the development of those policies in the past.
Your publications are on web-based publications now, aren't they?
Policy publications? Mm-hmm. Correct.
So there's no mailing actually that goes on if you post a policy or a rulemaking on the web, is there? When we
follow the procedures to make a rule change and we do a public hearing, we do physical hard copy mailings.
And do you know how many of those mailings you do for any rulemaking hearing?
It depends on what division or office it is. For example, in the Office of Regulatory Services, they'll do a mailing. It'll usually cost for a public hearing about $1,000 in postage, another couple $100 in terms of putting the documents.
Isn't it true that they mail only to people that request to be mailed to, and in fact they could request to receive the notice by email if they wish to? Isn't it true that you could do it by email at no cost if you wish to?
I do not know if that's true or not.
Mr. Hamilton. Any other questions? I've got 3 Marks up here. Mark Brothers, something. We ought to Y'all ought to be able to come up with something between you.
No remark. No remark. No relation, Mr. Chairman.
Yeah. We have no further questions for you.
No further questions? Thank you.
Are there any other questions from the committee? Hearing none, I'll ask for a motion.
Move to pass. Second.
Have a motion and a second to pass. All those in favor signify by raising your right hand. Motion carries unanimously.
Representative Butler on the reorganization bill, and I've made a commitment to several people. I'm going to try to figure out the APA standards in the new bill and maybe put this in it, but we'll continue this dialogue. Thank you. Thank you, Mr. Chairman.
Okay. Next on the agenda is House Bill 82. Yeah. At this time, we're going to hear from the Inspector General, Elizabeth Archer, on this bill. I will tell you that the bill went through subcommittee and passed unanimously with wonderful explanations by Ed and the ladies from the Inspector General's office. Elizabeth.
Good afternoon, Mr. Chairman, members of the committee. The purpose of this legislation is to statutorily establish the Office of the Inspector General. We are currently under executive order and have been since January of 2003. This legislation pretty much mirrors our executive order with the exception of four things. Subsection 4512.218, which is on page 6, which requires a mandatory duty on the agencies to report allegations of fraud, waste, corruption, and abuse. This legislation would also grant us administrative subpoena power, and that is found at 4512.215, subsection 5. There are some procedural safeguards with regards to the administrative subpoena power, that it can only be done during the course of an active investigation. This subpoena power would also extend to vendors who transact business with the state. Currently, our executive order is not binding on any outside vendor who transact business with the state, and we feel that they should be held to the same standard as the state agencies. And it would also amend the Open Records Act, giving us protection on those pending open cases. After we release a report, it is subject to open records, but we do everything we can to protect any whistleblowers who come to us in the course of an investigation. I'd be happy to answer any other questions that you may have regarding this bill.
We have questions. 15. Who's on 15?
That'd be me, sir.
Mr. Powell.
How do?
Good afternoon.
I'm sorry I was almost late getting to this like I was in the subcommittee to hear y'all's presentation. By putting y'all's operation into basically solidifying it into statute, is there a cost involved? Has there been any physical note done about what this may cost? I mean, right now y'all are operating strictly under the jurisdiction and the orders of the governor.
That is correct. There is no additional cost to this. Our budget will not change. I also take on a current caseload, which is unlike any other IG in the country.
How many employees do y'all have?
I have 3 deputy inspector generals, 1 executive assistant, and myself.
5 total?
Yes, sir. Our jurisdiction extends to 86. A little over 80 state agencies and 130,000 state employees.
And by solidifying this with these extraordinary powers by law, you don't foresee there being any physical impact as far as an increase in cost?
No, sir, I do not.
Mr. Ross.
Thank you, Mr. Chairman. Ms. Archer, I think I remember this bill from last year.
Yes, sir.
Tell me or help me understand again what it is that this office does that a district attorney's office could not do.
We do not have any criminal authority. Our investigation powers are only administrative in nature. We recommend procedural and policy changes to help the agency prevent future reoccurrences of fraud, waste, corruption, and abuse. For example, we released a report yesterday on the Department of Human Resources. It was not a criminal matter, but we took the position that it did violate good government. There should have been oversight over the consultant that the department was using, and they should have been tracking that. That is not something that the Attorney General would have engaged in, nor is it something that the district attorney would engage in. But that is something that we would do as an administrative body.
Why would they not engage in that? Because isn't it true that from time to time they do look at cases like that and they do conclude that there is not sufficient evidence of criminal conduct, and therefore, they're not going to go any further with it?
But in this case, there was an administrative need for change. We recommended that they needed to have oversight with regards and justify why they needed to use an out-of-state consultant. I mean, those are the kind of things that we did with regards to this case. I don't know if I answered your...
Mr. Happ.
Thank you, Mr. Chairman. Is this an administration bill? The governor's office?
It's an ethics, but it's driven by us. This is not by the governor's. Yeah, it's a department bill.
What is, you realize the legislature doesn't have any subpoena powers?
Correct. I'm aware of that.
But you're asking us to give the Inspector General, who is governor's appointee, power to subpoena not only government officials and agencies, but also in certain instances, as I understand it, private businesses. Is that true?
Just those vendors that transact business with the state. But if I could get back to the subpoena power. Currently, the Inspector General within the Department of Community Health has subpoena power. He has criminal and civil subpoena power. The Inspector General that reports to the Secretary of State has both criminal and civil subpoena power. The Office of Consumer Affairs has criminal and civil subpoena power. The Office of Banking and Finance has criminal and civil. Department of Insurance. We are the IG for the state. The reason that we currently, right now, I could go to the governor's office and ask for a subpoena. And if I were shut down, then where would I go? I mean, we should have the ability independently to issue those subpoenas if needed in this case, in any investigation.
Does the Attorney General have the ability to issue subpoenas?
They do.
What is the function of the Inspector General or what is the need for a separate Inspector General that would function independently of the Attorney General's office?
There are certain obvious overlaps. We can both investigate agencies. He can investigate the affairs of the state. My jurisdiction is very limited in that it's only the state executive branch agencies, and only in the case of fraud, waste, corruption, and abuse. I mean, it's very...
If I may also add, that's an excellent question. If I could also add to that. And I apologize to the Committee on Education.
Mr. Lindsay.
No. Because I asked the same question regarding two issues that you raised, and quite frankly, with the Attorney General, sometimes there's a conflict because the Attorney General's office is charged with representing the various agencies of our state, and this is Inspector General's job is to inspect those agencies. So there are some very real reasons why they can't simply go to the Attorney General's office. Regarding the fact that the legislature didn't have subpoena power, you dropped the bill. I'll co-sign it. I think that's something else that's been long overdue.
Easier said than done.
Yep.
Let me follow up with one other. Under the terms of this bill, and as I understand it under the executive order, that the Inspector General serves entirely at the pleasure of the governor. Is that correct?
That is correct.
Okay. What is there that would give us any safeguards from abuse by the governor or governor's staff of this position and the subpoena power that goes with it?
If I may, if you look very closely at the subpoena powers that we granted, anyone who is subject to a subpoena has the right to go to court and seek redress from the subpoena. I made sure that was placed into the bill as well. in order for there to be an additional oversight to make sure that the subpoena is being issued for the right reasons and not simply being issued for some type of political reason. That's why I put that language in there to provide that kind of safeguard.
What about, and again, I'm looking at this not just in terms of who the current governor is or who might be the governor in 4 years, but you're talking about a statute here that presumably would go on. If a complaint's made against the governor, how would that be handled?
We have investigated the governor in the past, and so that you know, we do have built-in procedural safeguards. When I meet with the governor, my report is already completed. I mean, there is no, all the memorandums of records are done, the tapes have been transcribed. I mean, it would be very difficult, or in fact, very easy to track if I had been swayed by the governor or anyone. So, I mean, that's how I have been able to protect myself during the course of my time here as the Inspector General.
How many investigations have you done in the governor's office during your time?
2.
Have you ever? What was the result?
One was the airplane, the use of the airplane, and one was the investigation regarding the DNR. Name escapes me for just a moment. EPD Director Carol Couch. Okay. And I did actually interview the governor with regards to that. That case actually was unfounded, but I did conduct an investigation, and I did question him regarding whether or not he had placed any pressure on the EPD Director to rule a certain way.
Okay. But in abstract terms, there is a conflict there for anyone serving in the position of Inspector General who serves at the pleasure of the governor if you're tasked with an investigation of the governor or his or her office. True?
That is true. And I know that you don't know me, Mr. Representative, and all I have
Nor
is...
you me.
That's correct. But I have been able to conduct my affairs.
But I'm not.
No, I understand the question.
I don't mean in any way to impugn you or the sitting governor. What I'm saying is I'm asking this in the abstract, or based on the fact that there will be other individuals holding those positions down the road, and I'm looking at just from the perspective of whether or not that this is a good idea in the abstract.
The only thing that I can to say to that is that there are 13 executive IGs in the country, all who are in the same position that I am, that serve at the pleasure of the governor. And I'm sure that is a common concern.
Do they all have subpoena power?
They all have subpoena power.
Okay.
They all 13. And
13
we can provide,
out of the 50 states?
That's correct. There is a federal IG in almost every division in federal government. There are IGs in almost every agency in Florida. There are city IGs all over the country. I mean, so it's not a unique concept, and they've all been able to coexist with both attorney generals, auditors, and comptrollers. And I'm sorry I haven't had a chance to read this entire bill, but would this bill give the Inspector General power to initiate investigations with regard to the legislature? No, or the judicial branch.
No, just within the executive branch?
Just within the executive branch of state government.
Okay. Thank you.
Mr. Mosby.
Thank you. Does the Office of the Inspector General have to be codified in order to have the subpoena power?
Yes.
Really?
It does. The power of the subpoena comes from being statutorily established.
Okay.
And let me also add that in terms of making sure that this works or not, we have in here a sunset provision.
That's correct.
If this doesn't work, it automatically sunsets 2013.
Mr. Powell.
Thank you. And I want to thank my friend over here at number 17, Mr. Hatfield. He started bringing around some questions that I hadn't thought about, but I couldn't quite figure them out until he said them. I've got a concern now that you're going to be appointed, or whoever the Inspector General is going to be appointed by the sitting governor to investigate those things that fall under his purview. You won't have the authority to investigate any legislative business or any of the judiciary. So basically, we're going to establish an agency, another agency by statute, appointed by the governor to investigate his own people that he already has the power to do so right now. Is that correct? Right now, you can investigate anything that falls under the governor's purview, any departments and agencies.
That's correct. Any commission, boards, authorities, that's correct.
And the idea of doing this just to give subpoena powers, if these department heads are appointed by the governor and everything that falls under the executive agency, if they're not forthcoming in revealing the details of the questions from his inspector general, why do we really need that? I mean, I've got some concerns that it might be used, as what my friend from Waycross said, that this could be misused. Certainly not any implications toward your character or the current governor. But you may not always be the inspector general, nor will he be the governor in 2 years. So somebody else is going to be following up. I'm starting to have some concerns that somewhere down the road that this could be something that could be misused, or an agency that could be used for vendettas, or am I just...
No. If I understand your question, when we receive a complaint, I always take into account, I mean, obviously we need to, where it's coming from. I mean, when we recognize that, I mean, there are sometimes that people come to us and they're 1 foot in the grave and they want to use us for that reason to get back at an agency. And we have been very good in rounding out those issues with minimal disruption to the agencies and trying to ferret it out. But I mean, it's a legitimate concern, and I mean, it's kind of at a loss as to how to answer the question. I mean, yes, there could be somebody else. There could be a new governor.
Let me ask you this then, as far as a subpoena or legal investigative, under the duties that y'all function under now.
Yes, sir.
If y'all uncover something that is criminal, or something where y'all asked a specific question or asked for documents, if it's refused, can y'all not go to a district attorney or to the attorney general's office to ask for their assistance and to follow that chain for them to issue the subpoena? Can you do that now?
Well, again, the inherent conflict is if we are looking at a state agency that the Attorney General, in essence, represents the state agency, that in itself would be a conflict. How we've been able to work for any documents that we need, I mean, if we bump up to criminal, we work with the GBI, and we have worked very closely with the GBI, with Director Keenan. In fact, we have worked at least 3 cases where we have been provided an agent to work with us, because we understand that we don't go into the criminal, and we understand that we only get one bite at the apple with that. So we do call in extra reserves, so to speak, in assisting us with our investigation. So we partner up with other agencies that have the resources that we need.
So you do work with these other
absolutely.
agencies
We work
that
with
can
audits.
issue subpoenas?
Sure.
And
Well, the GBI, if I'm not... Yeah, but we wouldn't go through a subpoena through the GBI. We can right now get the documents we need, and quite honestly, I've never had an agency tell me no, because nobody wants to be that agency that says no with regards to, a document request.
Representative, if I may get back to the original point, the fact of the matter is the subpoena power is necessary in order for us to track it down to the final source, which oftentimes involves the vendor that's having the relationship with the state agency that's under investigation. Without that subpoena power, they're not able to do so. Keep in mind that a large part of what the Inspector General does is this involves not so much, while if it leads to criminal, they turn it over to the criminal matter, but a large part of what they're doing is looking at fraud and waste that may very well fall below the level of criminal activity, but certainly falls within the purview of civil concerns, and that's generally where the Inspector General is. And, I have tried to put into place here safeguards dealing with the misuse of the subpoena power by allowing folks to go to court and to seek redress and to try to quash a subpoena should they feel it to be given for unfounded or even worse political reasons. I'm not sure what else can be done in terms of providing added protection to the private citizen other than that. I think that's the best recourse is an independent judiciary. That's why this organization can inspect or investigate the judiciary. We have set up an independent judiciary to do just that kind of checks and balances, to take care of those concerns.
So I guess what I'm sitting here trying to put all this together. I'm trying to weigh the benefits as opposed to the possible non-benefits to it. But since they can already deal with, the IG's office can already deal with DAs and law enforcement officials as far as to issue subpoenas and to keep a proper chain of evidence, so to say.
The DA is only going to come into place when there's prosecution, when there's criminal activity. Like I said, by and large, the activities of the IG's office is dealing, when they find criminal conduct, they turn it over to the DAs and the proper criminal investigatory agencies. This agency, by and large, deals with that which falls below the level of criminal. That we're basically filling a gap that exists that cannot be filled without this kind of oversight and the delivery of this kind of subpoena power.
How I refer to it is just because it doesn't violate the law doesn't mean it doesn't violate good government. You know, and he's absolutely right. The only time that we, when it's criminal, we pass it on. In fact, we have passed it on to the Attorney General's office. Any cases that we've had, a couple of cases that we've passed over to them. Our most recent one was indicted. It was a 43-count indictment in Fulton County Superior Court. So, I mean, we work in tandem.
Mr. Hatfield.
I promise it's just one question. Aside from the Attorney General, are any of the agencies that have subpoena powers, or any of them agencies that are not governed by or controlled by a board as such?
The Secretary of State IG reports directly to Karen Handel. The Inspector General in the Department of Community Health reports directly to Dr. Rhonda Meadows. And those are the two IGs. There is also, I forgot, there is also an IG in the Department of Human Resources that reports directly to the Commissioner, but only in the cases of child death in defect situations.
Are their subpoena powers limited to specific areas?
Yes. I mean,
just within the jurisdiction of those
their
departments?
Office, correct. Like with Medicaid and the Department of Community Health and those kind of issues, yes.
Mr. Lindsay, this is your bill, and I'd appreciate if you'd make a statement.
Well, getting back to the original point, we've been taking a look at the issue of fraud and waste in state government for a while. I had the privilege of carrying 3 years ago the False Claims Act, which tried to deal with this in a different direction in terms of allowing for private citizens to bring actions where they found fraud and waste in our state government. This agency is in place to try to ferret out such fraud and waste within the state government and try to do its job effectively. Quite frankly, it cannot do its job effectively if it cannot trace the fraud or waste back to perhaps all the parties involved, which includes independent outside vendors at times. We have tried to put into place the necessary safeguards provided by an independent judiciary to make sure that should the subpoena power be abused, it can be the courts can check it. As was noted in the presentation, the subpoena powers that we are asking for are not unique to an IG's office, but are also available in other agencies where there's the necessity for this kind of investigation to take place. Particularly at a time when we are trying to deal with a tightening of our belt, we should be very concerned about making sure that every nickel that's spent by the state of Georgia is spent wisely, and an independent, rather a Inspector General's office that has the necessary power and authority to ferret out this kind of abuse is extremely critical, and I ask for your favorable consideration of this bill.
Mr. Powell, one more.
Chairman, and to my friend at the podium. I just keep sitting here in mind thinking that the problem shouldn't be anyone under the governor investigating any of the administrative officers and executives. The real problem has came from the legislature trying to get straight answers from all of these. Did you ever consider putting this, maybe the AG solidified to be appointed by and to be under the appointment powers of the General Assembly?
No, I did not, and I think I felt that well, it's by its very nature an executive department, and so I think it would be inconsistent with the legislative branch. I think that there is a separate concern out there that is very legitimate, as I said to Representative Hatfield a moment cryptically, but with some seriousness. You and I have a different role when it comes to the executive department, when it comes to investigations, and I would agree with you that our power is somewhat limited by the fact that we don't have subpoena powers, and I hope, unlike some other states and unlike the federal government, and so I would hope that at some point someone drops a bill, and I'll be happy to co-sign it.
That bill was dropped in. I dropped it 3 weeks ago, and you're welcome to go sign it.
Tell me the number, and I'll go up and sign it this afternoon. But that does not take away the importance of this particular bill, and I would ask for you to consider the merits of this one as well. Both fulfill a very vitally important part of our system of government.
Does anybody on this end have anything to say? They're not going to get to say anything else. Mr. Other Powell, what number are you?
This question may have already been answered since I came in late.
Well, so did I, so don't feel bad.
In paragraph 1 of 210, this line 16, 17, why is prosecutable fraud excluded?
Because it gets back to the issue of not having criminal authority. If there is criminal conduct taking place, that's passed along to the appropriate DA or Attorney General's office.
Yeah, I guess my question is that if you don't become aware that it rises to the level of prosecutable fraud up until you're 3/4 of the way through with the investigation, would this language not exclude anything that you had found out during the course of it, made the investigation invalid? I guess that's...
No. As a matter of fact, what happens when the criminal activity is discovered, that gets passed along to the appropriate agency to continue that investigation. Nothing gets lost here. But basically, as I was explaining a while ago, Inspector General's office falls, as a general rule, falls just below the level of inspecting criminal activity. When they discover criminal activity, they are charged with turning that over to either the Attorney General's office or the appropriate DA's office. When it falls below that level, that's when they continue on with their investigation.
Thank you.
And please.
And just so I can add to that, just because we pass it on doesn't mean that we stop looking at it, because we really believe that if it doesn't go from 0 to 60 criminal unless there's an administrative breakdown that allowed it to occur. So even though we pass it on to the GBI to handle it for any prosecution that they see, or the Attorney General, we handle it from the administrative point as to whether or not there's any changes that need to be made to prevent this from happening in the future.
Who's 25, Ms. Howard? Your own.
I've gone back and forth on this bill, as the author may know.
I'd rather you go forward.
Okay, I understand. And the reason that when I've been on the again side, it's been because it is statutorily creating an office and taking away from the next governor whatever right he or she would like to have in relation to ethics. This governor had a lot of things that he did about ethics. Other governors, I hope, will do more. So it really takes away in some way in the future from the governor's prerogative.
I'm not sure I see how,
but the real question I've got posed to you as author is, if we wanted to make this the most effective, why wouldn't we put a state whistleblower effect that rewarded the whistleblower in the way that the federal statute does? Have any of the other Inspector General statutes done that? And then, Tiny, I didn't know we had an Inspector General in DHR or in Medicaid, and do either of those people have any statutory authority?
We didn't know either until I came back in 2006 that there had been and that was created by the agency head, that they had the discretion.
Not
to do that.
statutorily, not by executive order. Just,
Correct.
So obviously didn't have powers outlined.
But not like this. But I mean, they do report directly to the agency, and it was created by the agency and/or commissioner.
So why shouldn't we have a state whistleblower statute that would benefit the way the federal statute does?
We do have a whistleblower statute. I will agree with you, it's probably not the strongest. One of the things that this bill does now, which we did not have before, is that we have the authority, if a whistleblower is retaliated against, we have the right to investigate separately that retaliation.
But
I think
you don't protect that whistleblower statutorily, nor do you reward that whistleblower with
well, I mean, that's
money.
I mean, there's so many other factors that really take, that go into account. I think, that's for a court of law to determine as to whether or not they get their job back or their compensation or their benefits. But, I mean, the cornerstone of what we do, we need a strong whistleblower. I would agree with you. And I think that this statute does give us a lot more ability to protect them than it did in the past.
Well, and let me add, it gets back to my point that I raised with Representative Powell. The fact that this bill does not cover every possible means of ethics reform does not mean it should not move forward. It is, in my opinion, a significant step forward toward dealing with fraud and waste within the government. There are others as well. Your idea regarding expansion of whistleblowers is one of them. I know that's also a point of great concern for the chairman of Judiciary as well. Representative Powell also raised a good point in terms of strengthening the power of the legislature to also have additional oversight.
I wonder if we could
powers.
save money in DHR by taking the inspector generals out of Medicaid and DHR and putting them in, assigning those duties to Ms. Archer's office.
I think that quite frankly, my experience, quite frankly, with the False Claims Act is that given the amount of money that goes through Medicaid, Medicare, and given, quite frankly, all the studies that show the level of possible fraud that takes place or abuse that takes place within Medicaid or Medicare, I think a targeted IG within that department is very well placed. And I would not want to see that their concerns be lessened, quite frankly, by another bill. Like I said, the False Claims Act is also zeroed in on Medicaid, Medicare fraud as well, because it is an enormous problem given the enormous amount of money that goes through there. So I wouldn't want to take their eyes off that ball, that one iota.
Any further questions? Hearing none, I think I'm going to take the advice of my mark to the right. And could you amend your bill so that the Appropriations Committee could have subpoena power to all department heads? I will.
I have the same difficulty getting facts out of certain departments as well.
I will remind the entire Governmental Affairs Committee that this did go through the subcommittee, and the people that were asking most of the questions were all on that subcommittee. So we have heard some of this. With that said, I'll ask for a motion. Have a motion. Do I hear a second? Okay. Do pass by substitute. Mark, and I heard another one. Who did second down here on the right? Mr. Powell. All right, you. Yes, sir.
I want to move the table.
That override there. Move the table. All right, we've got a move to table the substitute motion. I have to have a second. Have a motion and a second to do substitute. All right, we're going to vote on.
I believe, Mr. Chairman, that the table motion is superior.
And I don't have to have a vote?
No, you do have to have a vote. That's my point.
Well, that's what I was going. That's the one we're going to go on. The motion to table. All those in favor signify by raising your hand. 4, 5. I've got 5 now. Those opposed, like sign. Okay. Motion to table carries.
Thank you, Mr. Chairman.
This committee is adjourned.